Tomorrow, our nation's highest court will be hearing a pivotal case concerning the gender mutilation of minors. Now, this is something we've been working on going back to 2017 as we helped shape one of the first laws that went into effect in Arkansas, or was passed in Arkansas. It's been challenged there as well. Now, 26 states have these laws protecting minors. One of the states, Tennessee, Senate Bill 1, which prohibits these experimental and irreversible procedures on children before the age of consent, is being challenged before the court. U.S. versus Skermetti. And we want to preview what the court might hear tomorrow. What are the arguments that those that are defending these laws, what will they be making tomorrow, and what might the opponents be making? And joining us is one of the men who has been leading this effort. He is the Attorney General of the state of Missouri, Attorney General Andrew Bailey. General Bailey, welcome back to Washington Watch.
Thanks for having me on, Tony. I appreciate you.
You have been on this for quite some time. Ever since you stepped into that office as Attorney General, you know the dangers and the harms behind this. So what are some of the arguments that the proponents of these laws protecting children will be making tomorrow?
Well, it's really a states' right issue. I think the 10th Amendment is the overlay to all of this. And the 10th Amendment says that any authority not given to the federal government or denied to the states is enjoyed by the states and the people of the states. And it's plenary power. The federal government is a government of limited and enumerated authority, while the states retain residual authority. The constitutional challenge to Tennessee's bill asks the question, can states protect kids? I mean, at its most fundamental core, that's the question before the court. And the plaintiffs here have raised an equal protection challenge, saying that it is unequal application of the law to single out different groups of people who can be then denied access to specific medical care. And our point is, number one, it's not medical care at all. It's woke left-wing experimentation for which there are zero FDA approvals for irreversible surgeries. There are zero FDA approvals for use of puberty blockers and cross-sex hormones in the treatment of gender dysphoria. And so the state absolutely has a compelling interest in protecting kids from this kind of mutilation.
Where might this go if the Supreme Court were to side with the opponents of these laws protecting children? What other things might this open children up to?
Well, I think it's a parade of horribles. Look, if states can't draw distinctions to limit access to certain medical procedures or certain other items that are otherwise available to adults in the marketplace based on the child's age, then no way that a state can prohibit consumption of alcohol before 21. No way a state can prohibit a juvenile getting a tattoo before the age of 18. I question at that point whether or not kids can be restrained by law in safety seats. I have a 2-year-old, and the state mandates that I use a certain approved safety seat for that 2-year-old. Well, if the Equal Protection Clause says a state can't make those distinctions based on age or gender, then those laws are subject to challenge as well. And so again, it's a very slippery slope that is completely unprincipled. And think about this. I mean, again, the question under the Equal Protection Clause analysis is whether or not the state has a compelling interest and has chosen a means narrowly tailored to achieve that interest. Those types of laws have been upheld in the past. The same reasoning and rationale should apply here. But it's also dripping with irony that this law protects all children from experimental mutilation. And yet the plaintiffs who are against the law say, well, no, certain individuals should be subjected to these dangerous procedures based solely on a mental health disorder. It's absolutely hypocritical, and that's why I think ultimately their argument fails.
And Attorney General Bailey, in the state of Missouri, it was one of the states that actually passed an amendment on the ballot in November regarding abortion, but it was reproductive freedoms, which sweeps into, as many read into this law, and obviously it'll be determined by the courts, the whole issue of gender mutilation, these experimental procedures. Could this not also open the door to driving a further wedge between parent and child, and the right that a child has versus the right of a parent to determine what the child has access to?
Yeah, Tony, it's a great point. And let me just sharpen it and say that it is an absolute attack on parental rights. And certainly that's true in the case of the amendment that was forced on the people of the state of Missouri by outside interests using these broad and vague terms like reproductive health. The idea is that they get a toehold, and then again, they line up a parade of horribles. It's an assembly line of death and destruction that follows, and certainly that's what we're fighting against here in Missouri. And we're proud to have partnered with 26 other states to fight to defend Tennessee's law in the United States Supreme Court to prevent this kind of gender ideology. It is an insidious ideology that has infected the public domain, our public institutions, and we've got to take a stand and fight back. I'm excited to see what the court does and confident in the ultimate success on this case.
That's my final question. We've got 30 seconds left. Based on the court previous decision, do you think the court will rule in favor of Tennessee?
I think the court will, because again, what the proponents, what the antagonists against the law, the proponents of gender ideology, what they're saying is that there's some kind of equal protection constitutional right to mutilate children. Certainly the drafters and ratifiers of the 14th Amendment would have found that to be abominable. And certainly that's not in the text, history, or tradition of that constitutional amendment. And that points to our ultimate success in this case.
All right. Attorney General Andrew Bailey, thanks for joining us. Always great to see you.
Thank you, sir.